Hey class, today we're going to talk about contract defenses. Like any other legal action, there are means of defending against an invalid contract, either in the making, the accepting, or in the consummation of or consideration. So let's begin. Uh, every party to a contract has to have capacity, and we've talked about this idea in the past. Uh, the idea of capacity, you have to be of a certain age. Um, so you have to be an adult to enter into a contract for over $500. You have to be mentally competent. Um, you have to have the ability to understand what the agreement is you're entering into. In other words, um, you have to you can't have had your ability to make legal decisions taken away from you by the courts. Um, you can't be intoxicated or under the influence of alcohol or drugs. Um, if the other party with whom you're contracting knew of your intoxicated condition, that's going to be a pretty important um, factor to remember. Excuse me. Um, if you don't have capacity, so you're under the age of 18 and you want to enter into a contract for over $500, for example, uh, you have the right to void the contract. What that means is you give back the goods that you purchased and they return your money. Okay. And the concern here is that somebody who's under the age of 18 might be taken advantage of by somebody over 18, okay, due to their lack of experience in the world and that kind of thing. As we always talk about, you and I both know that there are individuals under the age of 18 who are very canny and very savvy, but then there are also others who aren't. And so the law basically goes to the lowest common denominator and wants to protect everybody under the age of 18 with this blanket rule, or with that blanket rule. Now, there is a thing of implied affirmation, which is important as a wrinkle for having lack of capacity. So, if a person making a contract has lack of capacity in the offing, and then the person regains or gains their capacity. So, you are 17 and it's the day before your birthday, you make a major purchase, and then the next day you turn 18. Or you are intoxicated and then you make a purchase and then you regain your lucidity, and it's a temporary condition. Well, and that person who had lacked capacity continues to retain the benefits of the old agreement. In those cases, then the person is obligated and bound by the contract. So if you form a contract, you lack capacity, but then you continue to enjoy the benefits of that agreement and you've gained or regained your capacity, then you will be obligated and bound by the contract. Okay, so think of that in terms of purchases while you're intoxicated, or in the example I gave, you're underage, you make a major purchase, and then you become 18. If you retain that property, you're going to continue to be bound by the contract. Now, there are other defenses. Lack of capacity is certainly one you need to check into. And then, of course, whether or not the contract is illegal. Okay, your textbook talks about this idea that the subject matter or purpose of a contract that is illegal is void. It's as if it never happened. Okay, this is an important one. This is a really important idea. It's an illegal contract. It's going to be voided. You can't contract to do illegal things. Okay. Duress. Okay. If someone is asserting wrongful pressure on a person, in other words, coercing them into a contract they wouldn't otherwise have engaged in, then that's going to be a contract made under duress, especially if that deprives a person of their free will or any real choice in the matter. Okay. Now, this is tricky because how do you prove that somebody wouldn't otherwise have entered into a contract? But nevertheless, that's the way the law is. So it becomes a proof issue. So personal or physical duress, you're being threatened, or somebody you love is being threatened, makes that a void contract. Economic distress is voidable. Okay, so if somebody is asserting or exerting, excuse me, some form of economic duress, then that's voidable. The courts give the choice if they have a finding that this was this economic duress being put on a person. The court gives them a choice, gives that duressed person a choice as to whether or not to reject the contract. Another common defense, unfortunately, is fraud. Okay, and there's two kinds of fraud, and Freud. There's two kinds of fraud. Fraud in the execution, meaning the contract, you don't know that it was a contract that you entered into, is a void contract. Fraud in the inducement, which is about deceiving somebody about the material, some material part of the contract. That's a voidable contract. Okay, and again, these distinctions of void versus voidable are important, obviously. Void tends to be much more final. Voidable becomes a choice. An unfair contract, if it is truly an unfair contract and the courts make a finding that it was an unfair contract, one side had an attorney, the other side didn't, there's obvious abuse in the formation of this contract, then the court may refuse to enforce part or the entire contract, but that's the court's decision, okay, as to what they're going to do with something like an unfair contract. And we're going to have lots of examples of all these kinds of contracts as we practice, okay. An ambiguous contract is also a possibility. A contract that is ambiguous is void if the parties use a term that is open to at least two reasonable interpretations, and each party reaches, attaches a different meaning to those terms. They reach a different conclusion as to what those terms mean. So there's that first condition. Parties use the terms that are open to at least two reasonable interpretations. Second, each party attaches a different meaning to the terms. And then third, neither party knows the meaning attached to by the other party. Okay, so basically, if the contract's ambiguous and the contracting parties act on the ambiguity, if one party misinterpreted the term, then read the contract as how the other party would understand it. Okay, so issues with the camera. The mistake of fact is also an issue. There's two kinds, mutual and unilateral. If two parties to a contract make a mutual mistake, okay, so you cannot form a contract if both parties are mistaken as to a basic assumption of the contract, of the underlying, some basic fact of the underlying contract. Okay, and if that changes the agreed upon exchange, then you can't make a contract because you didn't come to that meeting of the minds between the two parties. A basic assumption of fact might be price. Okay, it might be, I don't know, any number of things. It might be the color of the car that your contract, color of the car. It might be the model of the car. Okay, if there's a mutual mistake in a car contract. So the mistake regarding subject matter renders the agreement not enforceable. Like a mistake regarding the value of the car, nevertheless makes it legally enforceable. Okay, because if you enter into a bad deal and you don't know, remember, caveat emptor, let the buyer beware. These are mutual mistakes. It depends upon what the mistake affects. Okay, a unilateral or one-sided mistake is a legally enforceable contract. Just because you screwed up doesn't mean that the other party has to give back whatever it is that you dealt with and dealt in. Let's see here. The statute of frauds. The statute of frauds is a English law, common law, traditional thing. And basically, it comes out of the 1600s where the English Parliament had basically said, look, there are some contracts that are so important that the chance of fraud is self-evident. And because these contracts are so incredibly important, you need to have a written contract. So a contract has to be in writing if the contract is one of the 6 types listed on the screen. Okay. So if you have a contract that falls under one of these 6 categories and it is not in writing, it is unenforceable. So, for example, if you are talking about marriage, okay, if you are talking about contracts where the performance must take more than a year, contracts involving the transfer of land, okay, the contracts involving an executor of an estate who promises to pay the debts of the estate out of his own funds. The sale of goods over $500. And then the surety of another's debt. All 6 of these kind of contracts have to be in writing. Okay. Because of the nature of the contract, because fraud could be a part of such a contract. So, if the statute of frauds applies, the contract has to be in writing, the contract must be signed by both parties, and you have to have enough of the terms of the contract written down, the material terms of the contract must be written down, to demonstrate the agreement between the parties. So you have to identify the buyer. You have to identify the seller. You have to identify any, nature of the acceptance, nature of the consideration, or any special terms have to be written down. Okay. Now, there is a handy statute of frauds mnemonic to help you remember. And the mnemonic is my legs. Okay. Marriage, over a year, land, executory contracts, goods over $500, surety. Okay, that's just a handy dandy mnemonic. Again, there are certain exceptions to the statute of frauds. One is promissory estoppel, which we talked about in a previous video. This is the whole detrimental reliance thing. Full performance by one party, according to the terms of the contract, will also be an exception to the statute of frauds. That one happens actually more often than you think. And then if you're creating specialty or custom goods, that's also an exception to the statute of frauds. Because of the fact that, for example, a seller won't be able to resell a specialty or custom goods if it's returned under the statute of frauds. Please remember these exceptions to the statute of frauds. They will come up in any number of ways in your class as we practice this stuff. So what are the damages? Compensatory damages, of course, to make the party who's been wronged whole. Incidental damages or consequential damages. These are additional damages on top of the compensatory. Okay. Now, there are no punitive damages in contracts. We're not punishing anybody under contract law. You're making the parties whole, and then there might be these consequential damages that are written into the contract. So, for example, hey, if one of the parties breaches the contract, they'll pay compensatory damages and then additional consequential damages equal to $500 or something like that. Okay, now nominal damages is the idea that you're establishing economic harm, but it is of very low amount. Nominal damages might be $1. Okay, but that's still damages, but it's the courts making the observation that, okay, since an economic harm happened, then there's often some other thing that happens under a contract if economic damages are proved up. A declaratory judgment, basically the judge is making the determination as to who wins a case, okay, because a declaratory judgment might have influence in other legal matters or something like that. And then, of course, specific performance is enforcing the contract due to the unique nature of that contract. So specific performance, the courts might order someone to create whatever the product is, that unique product that you contracted to have made, and the seller refused to do so or reneged on the detail on the contract. Specific performance might be where the court orders them to meet the terms of the contract. Okay, so a whole lot of defenses, some statute of frauds, and some damages. I'll be posting some additional work to practice these ideas. As always, please shoot me an email if you have any issues with this class.